What happens during a criminal arraignment court hearing? Imagine standing before a judge for the first time after being accused of a crime. That moment is called an arraignment, and it kicks off your journey through the criminal justice system. This hearing is a key step where many important decisions are made. In most cases, your arraignment must happen within a specific time frame. In Texas, it needs to be within 48 to 72 hours after your arrest. If you can post bond before the scheduled arraignment, the hearing might be delayed by a few weeks. At the federal level, you usually appear before a magistrate judge either the same day or the day after your arrest. When you arrive at the court, the judge will read the charges against you directly from the court docket. This is your right under the Sixth Amendment of the United States Constitution. The judge will tell you exactly what crimes you are accused of, whether they are felonies like murder or misdemeanors, such as driving while intoxicated or drug possession. Next, the judge will ask if you want the court to appoint a lawyer to defend you. If you qualify financially, the court will assign a public defender or court-appointed attorney. Having legal help from the start is important because your lawyer can protect your rights and begin working on your defense right away. After the charges are read, you will be asked to enter a plea. You can say you are guilty, not guilty, or no contest. If you plead guilty, your case moves straight to sentencing. If you plead not guilty, your case will go to pretrial hearings and possibly to trial. A no contest plea means you do not admit guilt but accept the charges, often to avoid civil consequences. You can also choose to remain just silent, which is called a mute plea. The judge will then enter a not guilty plea on your behalf, keeping your options open. Following your plea, the judge will decide whether you can be released on bail or if you need to stay in jail. The judge considers factors like the seriousness of the crime, your criminal history, your ties to the community, and whether you might run away or pose a danger. If bail is granted and you can pay it, you may be released while awaiting trial. If not, you will stay in jail until the case is resolved. Sometimes, the judge will releases you under conditions, like restrictions on where you can go or what activities you can do. Once the arraignment ends, a trial date is set. This gives both sides time to gather evidence, interview witnesses, and prepare for court. If you plead not guilty, you will have the chance at trial to challenge the evidence against you. You can also present your own witnesses and evidence, and even testify if you choose. From a defense perspective, many attorneys will enter a not guilty plea at arraignment to keep all options open. This allows them to review police reports, witness statements, and other evidence before making any final decisions about your defense. Your bail status is also established during this hearing, which affects your ability to work with your lawyer and prepare for trial. Being released on reasonable bail or conditions helps you participate more fully in your defense. Remember, your right to legal representation begins at this first hearing. Having an experienced criminal defense attorney there protects your rights and helps you understand every step of this important process.